And news updates online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. We've talked off and on over the last couple of years because of some good investigative work and reporting by people like Carrie Severino about the particular type of lawfare advanced by the eco-supremacist activists and the associated front groups for their activities. Groups like Our Children's Trust, which file lawsuits like the one they filed in Wisconsin, was they filed a suit in Wisconsin that attempted to hold the state, effectively attempted to hold the state responsible for the weather. They use, per the name of the organization, they use children as the front. I mean, these are frivolous lawsuits, but it's politics by other means through the courts is the point. Corporate shakedowns, perhaps judges being compromised by attending conferences put on by these organizations, signing or vowing support for particular in support of particular pledges they want public figures, politicians, officers of the court to take. So the climate variety of lawfare is just as undermining with respect to the rule of law and equal justice, equal protection under it, as other instances of lawfare, in the realm of criminality that we talk about more often. And here we fold in our trial lawyer friends, one of the biggest funding arms of one particular political party, along with their government union friends. There's a case before the Supreme Court that is of particular interest to our next guest, and we're going to discuss it. He is Michael Mukasey. He served as a U.S. District Judge for the Southern District of New York, also as Attorney General of the United States under George W. Bush. Attorney General Mukasey, thanks so much for joining us. Appreciate it.
Thanks for having me. Good to be here.
So, lay out this Louisiana case that's made its way to the high court and the implications.
Okay. This Louisiana case really has its roots back in two wars. One is the War of 1812, at which point Congress passed a statute called the Public Officers Removal Statute that said that when you have a lawsuit where federal interests are at stake, that lawsuit can be taken out of state court where state biases prevail and brought into a federal court. Fast forward to World War II when President Roosevelt established something called the Petroleum Authority for War, where he wanted to get oil extracted quickly so that aviation fuel could be produced, and in particular, he wanted to get oil extracted from off Louisiana, which was very well suited for aviation fuel. And he contracted with various oil companies to start extracting that oil so that the war could be won with high-quality aviation fuel, and they started doing that back in the 1940s. Fast forward again to the 1970s when the federal government passes legislation trying to encourage states to improve the ecology and prevent damage to their coast. Louisiana says, fine, we'll do that, and they established a permitting system that was effective beginning in 1980 that said you had to get a permit in order to do certain activities, including extracting oil, but any activity that was started before 1980, when the law went into effect, was exempt. And, of course, the oil companies were extracting this high-quality oil beginning back during World War II. The ecological folks swooped down and brought lawsuit claiming, no, you're damaging you're causing erosion, damaging the coast, and they sued for damages going back to the 1940s. We said, wait a second, there's a law here that says we're exempt. And initially, the court read it that way, then did a 180 and said, well, we're not so sure. And the oil company said, no. We're going to take advantage of this federal officer removal statute. This is when a federal law interest is at stake. We're entitled to be in federal court where we get a fair shake rather than in state court where the judges run for office. Their campaigns are financed by the plaintiff's bar. And lo and behold, the rulings show up the way they did here in support of the plaintiff's bar. This particular lawsuit that I wrote about is being brought by a parish in Louisiana where there are something like 25,000 residents suing for tens of millions of dollars.
Mm-hmm.
And in fact, Louisiana recovered for erosion damage years ago from the claiming that the Army Corps of Engineers had caused it. And so they recovered on that theory. Now they've turned around and they're claiming that no, this is caused by the oil companies. So the question is whether it ought to be brought in a federal court where the companies get a fair shake, and that's what's before the Supreme Court.
Right. I mean, so the local yokels that have been captured in many instances by the moneyed interests in a particular locality or state don't just do the bidding because what does it matter to me? In point of fact, I'll be not only financed, but I'll be feted because I just extracted tens of millions, maybe billions of dollars from oil companies that's going to go into the coffers of, the government where I live. Yeah.
Right.
And but here's the thing. Now, I mean, that makes perfect sense what you're saying, and that you're more likely to get a fair airing in federal court removed from the local interest. But you still have this problem. I mean, this is clearly part of the climate lawfare strategy by these organized, climate groups, to be generous in terms of describing what they are. But I mean, you also have these stories I mentioned too, where you have climate groups. They just this last year they scrubbed the names of judges that they had posted on their website to credentialize themselves for having attended their symposia and so forth. But some of the federal judges were implicated too in terms of being basically, I would say, politicians in robes with a particular agenda as it pertains to these sorts of lawsuits.
Well, I'm not familiar with those situations, but here there's certainly a tilt in state court, and the companies believe, and I think with some justice, that they'll get a much fairer shake if the case is removed to federal court. The state has resisted, of course, and so the Supreme Court is going to decide whether this statute, going back to the War of 1812, which has been expanded repeatedly to make sure that federal interests get heard in a federal court, is brought in federal court, not left in state court.
Yeah, and the forum shopping that goes on too. I mean, we're very familiar with this at the local level in places like Madison County and Cook County in Illinois.
For sure.
This is part of what we're discussing in the context of this Louisiana case too. I mean, it's not just particular to oil companies and environmental damage. It's something that's sort of endemic to the civil justice system in states like Illinois and Louisiana.
Well, it's anybody with a deep pocket who is perceived to be on the wrong side of a social issue.
Yeah. Yeah, that about sums it up. Michael Mukasey, he served as U.S. District Judge for the Southern District of New York, also former United States Attorney General under George W. Bush. Attorney General Mukasey, thanks so much for joining us. Appreciate it.
Thanks for having me.
Dan Proft, Chicago's Morning Answer.
It's news, opinion, insight. This is Chicago's Morning Answer on AM 560. The Answer.
John was an active man. He'd go for runs, walk the golf course, and always take the stairs instead of the elevator. But then bone on